Also, I owe you a coffee.
I told you. All right, good afternoon, everyone. Welcome back to the Judicial Proceedings Committee. Today is Thursday, January 23rd, 2025. We're on voting list number 2. We've got 13 bills and a number of withdrawals. So I'm going to read the withdrawals first so that we can just move those out. There'll be the motion will be for an unfavorable withdrawn. So that includes Senate Bill 28, Senate Bill 39, Senate Bill 45, Senate Bill 71, Senate Bill 141,
Second.
Senate Bill 191, Senate Bill 206, and Senate Bill 300. The motion is for an unfavorable withdrawn. Second. Is everyone okay being recorded in the affirmative for the unfavorable? Excellent. Okay. We'll now move on to Senate Bill 92. I'm not quite, just before we prime this up, so we're good at 92, Senate Bill 92. This bill's not quite ready to move out yet, but I was going to have a brief discussion with the entire committee. Obviously, I think all of us have an interest in moving this bill, but we'll have counsel read it into the record, and then we'll talk about some of the difficulties.
So Senate Bill 92 alters the peace order statute. The bill adds the intentional visual surveillance of areas of an individual's residence where the individual has a reasonable expectation of privacy, whether or not prohibited under certain provisions of the criminal law article, to a list of acts for which an individual may seek relief by petitioning for a peace order. The bill expands available relief for final peace orders to include ordering the respondent to remove or reposition a device being used for visual surveillance within 15 days, and to refrain from further visual surveillance. There are no amendments in your voting packet.
All right, so the underlying, the conduct that we're talking about, this is a guy moving the cameras around on the property, and we talked about this a little bit earlier. The underlying conduct seems like it would fall under harassment for what you could get this peace order for. Harassment is already in the statute. So we're trying to figure out how to play around with the language to ensure that the conduct that we're trying to capture is at least considered to be harassment, because it seems like it is harassment, but I don't know how, so we're still going to play around with the language. If you look at the bill, we create, on page 2, lines 25 through 28, that's what we're trying to capture and slide that under whatever definition of harassment is. So we're going to assign a work group to continue to work on this. I think we all, because there was a work group that did come up with this that approved this general concept and language, but the way that it's drafted now, I don't think it captures the actual, and we talked about this, Mr. Vice Chair, you can talk, I don't think it captures the activity that's happening. If we pass this bill, I think that it's still going to be a problem. So we've got to kind of continue to go back to the drawing board. But if anyone else wants to comment, I'd like to hold this and continue to work on it. Okay? All right, Senate Bill 92 is held. We'll now move on to Senate Bill 123.
Senate Bill 123 pertains to boating accidents. The bill requires that the operator of a vessel involved in a collision accident or other casualty that results in bodily injury or to the death of another person stop the vessel as close as possible and return to and remain at the scene of the accident until the operator renders assistance and provides information. The bill establishes criminal penalties for failure to comply with these requirements and establishes a penalty for failure to comply with the existing duty to render aid and provide identifying information at boating accidents. The bill's new requirements for stopping as close to the scene and returning and remaining at the scene of an accident are similar to requirements related to motor vehicle accidents under existing law. The new graduated penalty provisions of the bill are generally identical to the graduated penalty provisions applicable to motor vehicle accidents. There's no expected fiscal impact. And there are no amendments in your voting packet. I would note the bill is identical to a bill that JPR passed out and the Senate passed unanimously last year.
All right, what's your pleasure? Discussion? Motion's for favorable.
Okay.
It's been seconded. Do we need to do a roll call, or is everyone okay? All right. Senate Bill 123 passes unanimously. I'll note, since we haven't been doing roll calls, Senator Folden and Senator McKay have excused absences today. Also, Counsel Shamari is out because he's about to become a father, so that's great. And in his absence, we have Counsel John Edwards will be joining us, and he'll be here taking over his portfolio. But today, Jamie is going to be handling the bills that Shamari generally had. All right, we'll move on to Senate Bill 141. My apologies, 142, Senate Bill 142.
Senate Bill 142. This bill establishes that a spouse who is the alleged victim is competent to disclose a confidential communication between the spouses occurring during their marriage in a criminal action in which one spouse is charged with a crime against the other spouse. However, the bill also provides that a spouse may not be compelled to testify to a confidential communication under these circumstances. A spouse includes a former spouse. There are no amendments in your voting packet, and that's it.
The bill, I think the bill speaks for itself.
Move favorable.
Second.
All right, there's some discussion. There's been a motion for a favorable. Senator Sidnor has seconded it. Do we need a roll call? Is everyone okay being recorded in the affirmative? Okay, excellent. Senate Bill 142 passes unanimously. We'll now move on to Senate Bill 150.
Thank you. Yes. This bill alters certain provisions relating to the filing, maintenance, and transmittal of land records, and generally relates to the recordation of instruments affecting real property and land records. It was indicated that at the bill hearing that the purpose of the bill was to update sections of the real property article. And let's see, there were a couple of suggested amendments. There is an amendment in your voting packet, which I believe was introduced or was by the chair at the request of some of the parties that had testified on the bill. And let me, ooh, thank you. No, that's the, oh, sorry about that. Yeah. So in your voting packet, there is Amendment 213324/1 for Senate Bill 150, and there's an interlineated copy behind the amendment. If you turn to page 4 of the interlineated copy, this strikes a provision of the bill that authorized the clerk to refuse to record an instrument that does not meet the requirements specified in the subparagraph, and instead provides that a clerk may not be held liable for failure to document that does not meet the requirements of the subparagraph. Speaking with Mr. Taylor, evidently the concern of the folks that were proposing this was that because this provides specific requirements for things like page margins, if something was outside of those requirements, it may not be scanned properly, which could then create issues down the road if it's in the records and the records are not complete. So this was to address that. And then finally, on page 10 of the interlineated copy, this strikes in line 23 and 24, would return to the existing law. So it would provide for indexing of deeds and other instruments. This was evidently something that the system that the clerks use already does, and they had evidently asked to keep that in.
All right, there's been a motion for a favorable on the amendment. It's been seconded. Is everyone okay adopting the amendment? Is it on the vote on the amendment? Yes. Okay, excellent. Senator Henson.
Looking at the amendment on page 4, the language that's struck is the part that makes it discretionary on the clerk to record or not record. And then the additional language is what waives liability if they record and it's somehow beyond the margins or there's some sort of error in the transfer. Was there a reason why we struck the discretion to record or not record? Could we not have both things happen together?
That they could turn it away, and that they wouldn't be liable. Yeah, I'm not sure what the rationale was behind that request.
Okay. Thank you for the response. Thank you, Mr. Chair.
It's an open vote on the amendment. There's been a motion, there's been a second, the vote on the amendment, the adoption of the amendment is still open. Do you want to press forward? Do you want to, we could adopt the amendment and then hold the bill to seek additional guidance on that question if you'd like. It's up to you. We're still very early in session, so. Okay. Senator West.
Looking at the Maryland Land Title Association's comments where they suggested this amendment, and here's what they said. They said, a refusal to accept the document for recording would subject the title company or attorney that handled the closing, as well as the title insurer, to potential liability to buyers, seller, and/or lenders for either a failure to record or the resulting delay in recording while the matter is resolved and the document brought into compliance. So they're worried about liability, and they suggested this alternate language which would not create the problem of liability.
Need to help insulate them from liability. It's why we would take away the discretion as well that I think I'm trying to understand. Is it something about the modernizing of the process that means that I don't know if there's a rationale for taking away the discretion to record or not record, but the second part of what adds to it, I have no problems with.
I agree, actually. So let's adopt the amendment and then hold the bill. Okay. And we'll come back and get an answer. Is everyone okay adopting the amendment? Mm-hmm. Okay. So the amendment's adopted. You got the amendment number, right? Yeah. All right. Okay. All right. So we're going to hold the bill, and we'll bring it back as amended. All right. We'll now move on to Senate Bill 180. Yes.
Senate Bill 180 would provide that the period of expiration and renewal for a handgun permit issued to a retired law enforcement officer who's retired in good standing from a law enforcement agency in the state would be 5 years. As for fiscal impact, it's a 1 year impact of $170,000 and then nothing in subsequent years. Just by way of background, generally a handgun permit is valid for an initial 2-year period followed by a 3-year period for renewal permits. So handgun permit applicants, both for an initial and a renewal application, before submitting the application, need to have completed a firearms training course that's approved by the secretary that includes 16 hours of instruction if it's an initial permit, or 8 hours of instruction for renewals. Topics covered need to include firearm laws, firearm safety, handgun operation, conflict de-escalation resolution, anger management and suicide prevention, and a firearms qualification component for both the initials and the renewals. That includes a live fire shooting on a range and requires the applicant to demonstrate safe handling of a handgun and shooting proficiency with a handgun. I would note that the current law exempts a law enforcement officer who's retired in good standing from the firearm qualifications component. And that's it.
If you could just talk a little bit, just for context and just for the record too, just about the difference between LEOSA and then this, the current regime that we have, and then I know we're kicking it to 5 years and not 2 years, but you could have LEOSA and this. Just can you just talk about requirements for LEOSA as well? So
LEOSA is a federal law, stands for the Law Enforcement Officer Safety Act, and it allows, I believe, current and retired law enforcement officers to carry, and as long as they're meeting the qualification requirements, and we require LEOSA for a LEOSA permit to carry, an officer needs to be retired in good standing, and then annually needs to meet the same qualifications that they would as they would if they were an active law enforcement officer. At the hearing, there was testimony from FOP that not all departments give their officers the option of LEOSA permit. They would need to go through their department to obtain the LEOSA permit, so that's not always an option for them. Yeah.
So LEOSA is for interstate carrying. Right. Okay. What's your pleasure?
Second.
There's a motion for favorable. It's been seconded by Senator Muse. Do we need a roll call, or is everyone okay? Okay. Senate Bill 180 passes unanimously. All right, we'll now move on to Senate Bill 184. That's you, Josh.
Senate Bill 184 is a departmental bill that authorizes the Secretary of State to suspend or waive late filing fees for charitable organizations and establish related regulations. The bill establishes that a late fee may not be considered a delinquent account, requiring referral to the Central Collections Unit. And the bill also establishes that Secretary of State may cancel the registration of any charitable organization that fails to file its required annual reports, and establishes provisions for charitable organizations to request reinstatement of that canceled registration. The bill is identical except for a minor stylistic change to a bill that the Senate passed unanimously last year.
All right, there's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 184 passes unanimously. We'll now move on to Senate Bill 187.
Senate Bill 187 is a departmental bill requiring the Motor Vehicle Administration to disqualify any individual from driving a commercial motor vehicle for a period of 1 year if the individual, while holding a commercial license or instructional permit, drives or attempts to drive any motor vehicle while the alcohol concentration of their blood or breath is 0.08 or greater.
Just give us more context for like federal.
Yeah, so this is, the administration advised that this bill is intended to bring the state's laws in this regard into parity with the federal law. And they actually just sent me some additional information clarifying that. So the issue is that the federal law, which requires states to have these revocation provisions related to commercial driver's licenses, has a broad definition of the term conviction, which includes, let's see, a determination that a person has violated or failed to comply with the law in a court of original jurisdiction or by an authorized administrative tribunal. And the issue is that the test that shows that you have a BAC of 0.08 or greater, that would fall, like, if you fail that, that would fall within the federal definition because it's an authorized administrative tribunal. So what this is trying to do is basically just bring us into parity so that when the federal law requires us to make the revocation for a year, the state law is doing the same.
All right, excellent. Motion for a favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 187 passes unanimously. We'll now move on to Senate Bill 197.
Senate Bill 197 is a departmental bill that expands the membership of the Correctional Training Commission to include the Director of the Division of Parole and Probation. There is an amendment in your packet that's number 913625/1. The amendment would also add an employee of the Division of Parole and Probation as recommended by the union, which represents them, which is AFSCME, and the department considers that to be a friendly amendment.
So the amendment's been moved. It's been seconded. Is everyone okay to adopt the amendment? All right, now the bill's before you as amended. Motions for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 197 with amendment passes unanimously. All right, we'll now move on to Senate Bill 199.
Senate Bill 199 requires GOCAP instead of the Criminal Injuries Compensation Board to process and pay claims for reimbursement by specified healthcare providers for sexual assault exams and treatments. GOCAP advises that this bill conforms the law to existing practice. There are no amendments in your voting packet.
Motions for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 199 passes unanimously. We'll now move on to Senate Bill 202.
This is a departmental bill from the Department of State Police. Alters the circumstances in which a DNA sample must be collected and stored in the statewide DNA database system within DSP. It alters the individuals required to collect DNA samples and the process for collection of DNA samples from registered sex offenders. It provides for when a DNA sample may be tested, placed in the statewide DNA database system, or destroyed and expunged. The bill also requires a releasing entity who holds an individual in custody before they release an individual from custody to ensure that the individual's required DNA sample has been collected in accordance with the law. The bill prohibits an individual from refusing to provide a DNA sample as required and establishes penalties for violations of this prohibition. There's no expected fiscal impact. There are no amendments in your voting packet.
Hold on one second. Hold on. I think one thing for me is look, like if you refuse to do a breathalyzer test, like you get your license yanked, I don't think there's any criminal penalty associated, or it's certainly not a $10,000 fine associated with it. Misdemeanor and $10,000 for refusing to give a swab for DNA, that seems pretty heavy-handed to me, but so.
Can't you lose your driver's license?
Yeah, but you're not paying $10,000.
Well, yeah. But there is a penalty.
So I'd see, I don't know, there's a, we also talked about the commissioner who's gonna make this decision, or officer, we can have that discussion as well, but like, the penalty thing for me is, yeah, I mean, I get, yeah, I'm down for
Where's the
that.
penalty?
I structurally, I think we should
here
just
it
talk
is.
about this for a little bit. Senator James.
I agree with you, but I think the great selling point also of this bill is, as I understand it, if we do this, then all that backlog, we're going to get rid of it. It's not sitting around and it's not getting tested. So people are no longer in limbo, and prospectively, we're going to have this hopefully timely process and the clarity with the language as to how these cases are actually processed. Isn't that the intent of this bill, wouldn't you say?
So DSP, and I believe their government relations person is here as well, but they had advised the committee that there was an intent to get rid of the backlog, because they do have samples that statutorily they're not able to test. Now,
And this is separate, of course, from the
this,
rape
Well-
kits, which are, right?
well, so moving forward, it would
It is.
create new requirements for when DNA samples could be tested. And
Yes.
that's on page 5 of the bill.
Yes, I know.
And Mr. Chair, would you?
Yeah, please.
So those 4 situations would be, one, determination is made that probable cause exists for a qualifying crime in accordance with the Maryland rules. Presumably, that would be by a judge or a commissioner. 2, the individual has been arrested for a qualifying charge in accordance with an arrest warrant, which a judicial officer would be finding probable cause to arrest the individual because there's a warrant. 3, information is filed by a state's attorney for a qualifying crime. There's no judicial officer in that scenario, it's the state's attorney, but, and then 4, an indictment is returned by a grand jury charging the individual with a qualifying crime. Right, so an existing law provides for this. The bill alters it. It was just asked a question about expungement. So under the existing law, in general, DNA samples or records generated as part of a criminal investigation or prosecution are required to be destroyed or expunged automatically from the DNA database. If 3 conditions exist. Either criminal action was begun against the individual relating to a crime and it didn't result in a conviction of the individual. The conviction was finally reversed or vacated and there was no new trial, or the individual was granted an unconditional pardon. So the bill adds.
That's in the bill, right?
Well, so that's existing law, but the bill does add a provision relating to expungement. If you look at
that's right.
the bottom of page 6, beginning at line 23, provides, except as provided in paragraph 3 of the subsection, a DNA sample collected but not tested from an individual charged with a crime under 2504A3 shall be destroyed and expunged if the 2 following conditions are both met. At least 2 years have passed from the date of the collection and the DNA sample failed to meet the requirements for testing. And then the exception would be a DNA sample or DNA record may not be destroyed or expunged automatically from the state DNA database if, 1, the criminal action is put on the STET docket, the individual receives PBJ, or the trial for a qualifying charge under 2504A3, those are the qualifying crimes, remain pending for any reason.
What does STEP mean again, sorry?
Put it on the shelf.
Yeah, it's just kind of puts it in limbo
I
forever.
knew that, but what is it technically? I mean, STEP, like,
Well, it's
you can be in
diversionary.
STEP forever? Is that like being in limbo forever between heaven and hell?
Yeah, I don't think that
I'm
there's
not familiar.
actually an expiration, although we do provide for expungement of STETs after a certain period of
For
time.
DNA in this?
No, I'm talking about just generally the charges.
I guess what I'm trying to say is, I think this is a good bill. We can always make it better, but part of the complaint is that this stuff's been sitting around, and now we're saying, are we, or did I misunderstand you, that we could keep people's DNA if we put them in the STEC category, and we don't have any kind of parameters around the STEC category?
Yeah, I mean,
And I don't know what the proponent said.
Yes,
Maybe
yeah,
they had a reason for it, and they maybe should get back to us. Maybe they'd get back to us about how they would deal with that aspect of it. Because I think they were selling it as, look, we have a lot of stuff lying around. We're going to clean up our act, not let the old stuff languish, have a procedure for disposing of it, testing it, and a much better process going forward. But it seems to me that at least that provision continues to allow them to have languishing DNA. That may not be correct, but I don't remember them explaining that, unless somebody else remembers.
So Senator, if I'm understanding correctly, is the question that you were raising, generally there would be a 2-year shelf life on these things under that paragraph 2. However, if there's a stat,
Yeah.
it becomes unlimited.
Yes.
You're
more
I
articulate
hadn't
than
thought
I am.
about that. That I would read it the same way.
I mean, maybe not reading it right.
Well,
And we could
so
get-
the
I'm very
the literal,
interested. We could get
the
you all to
wording actually
explain
says,
to us why the stat.
may not be destroyed or expunged automatically from the database if well, it's 3 years before you're eligible for the record, not necessarily the DNA sample.
Right.
But,
May not be.
or the individual receives
Yeah.
probation before judgment.
Run stat. How do you read that?
Yeah, I mean, I would read it the same way. I can look into that further, Senator.
Yeah, because it's, they're almost inconsistent a little bit. I don't think anybody intended that, or it becomes circular. I'm very supportive of the bill, big picture, just want to make sure that it works. So that seems like something we should get some clarification on.
And DSP had advised that, again, the major issue with their backlog of DNA samples currently pertains more to an inability statutorily to test them because the current law calls for an arraignment to occur. There is definitely some disagreement about whether an arraignment exists either officially or just in practice based on the testimony that was provided. So DSP pointed out that the Maryland rules no longer provide for an arraignment. I think their research said that it was since the 70s.
Interesting.
Some of the testimony and information that was given to committee counsel was that it does still occur generally when individuals are not represented by counsel. This is an opportunity, not necessarily for probable cause determinations, but it's where a pro se defendant would be advised by the court of the charges pending against them. So I think there's a little bit of a disagreement about maybe just what's occurring in practice and what the rules provide for. But the DSP had advised that this was an attempt to sort of address those that they didn't have the ability to
I don't know if it's
to
unique to
test.
criminal law, but I got to tell you, in the civil area, you would never have us not know whether we have arrangements or not and what words to use. So that seems just like a little crazy to me. So maybe you could run that down because that just, that kind of ambiguity, and sometimes old habits die hard, right? Maybe people keep using that term and
Sure.
that thinking, and it gets into the vernacular even by a judge or prosecutor, but it's not really the statutory practice.
Right.
But I don't know if the whole committee went to, I would just like to know if we do that or not, just so I don't, I'm on this committee, I'd like to be able to tell people that I know the answer to that question.
I understand, Senator.
All right, thanks. Thank you, Mr. Chairman.
All right, so it looks like we've got to, if there's a sense, we're going to hold this. There's a sense we want to, pass this bill, but we've got some more work to be done. So we'll continue working on it. Sorry, Catherine, I see MSP's here, but it's JPR. What do you, yeah. All right, so we're going to hold Senate Bill 202, and we're going to move on to Senate Bill 203.
Senate Bill 203 is a departmental bill that simplifies and modifies the requirements for exceptional hauling permits issued by the State Highway Administration to haul certain farm products.
There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Senate Bill 203 passes unanimously. Oh, sorry, we can add. Okay. That's a good question, actually.
I don't know the answer to that, but I don't see why she can't be.
Yeah, I don't. Yeah, it's technically, yeah, it's our bill, and technically, I'm the vessel that, so yeah, there we go. Do what you want. All right, would you like to be added? Would you like to be added? Would you like to be added? Okay, so I'm gonna just recall, strike the vote. All right, it's an amendment to be, Senator James would like to be added as a sponsor. Anyone else want to jump on? Senator West, I'll jump on too. Senator Muse, anyone else? All right. Charles, Senator Charles. All right.
So, James, West, Smith, Muse, Charles.
Yep. All right. I guess it's fine. Put Smith on there. Then.
Be on there twice.
Be on there twice.
I don't think, I mean, I don't know, we'll find out when you send that over.
Double down on it. All right.
Interesting. We're about to get on.
All right. So now is everyone okay adopting the sponsor amendment? Yes. Okay. Now the bill's before you as amended. The motion's for favorable. It's been seconded. The bill passes 203, passes unanimously with amendment. Now we're on Senate Bill 205.
Senate Bill 205 is a departmental bill which specifies an exception to the general prohibition against the disclosure of any information concerning an applicant or recipient of certain services under the Human Services article in relation to adult protective services. Disclosure of information is not prohibited to an officer or employee of any state or local government or the United States if the officer or employee is responsible for conducting an investigation in an official capacity and the disclosure is relevant to the investigation. The identity of a person who makes a mandatory report of potential abuse, neglect, self-neglect, or exploitation of an alleged vulnerable adult may be disclosed if in accordance with the aforementioned provisions. The bill also expands the definition of health practitioner applicable to statutory provisions regarding the mandatory reporting by certain individuals of alleged vulnerable adults. There are no amendments.
So I think I like the bill. When you say, I know it's been motion for favorable in a second, but we have another bill in committee. We want to see if it covers the same situation, and if so, we might have an opportunity to have one less bill hearing. It's coming up next Tuesday. So we're just going to hold it until next week, if that's cool with you guys, just because it might be duplicative.
All right, last bill.
All right, last bill. Senate Bill 207.
Senate Bill 207 is a departmental bill that expands the list of circumstances under which the MVA is required to revoke a driver's license to include convictions and probations before judgment for certain drunk and drug driving offenses resulting in death or serious bodily injury to another person, and for failure to remain at the scene of an accident resulting in death or life-threatening injury. If an individual's license is revoked under those circumstances, the individual would not be authorized to file a reinstatement application until 5 years after the revoked license is surrendered. The bill also expands mandatory participation in the ignition interlock system. There is a letter in your packet from the MVA which details some of their thinking behind the bill, and particularly it goes into the decision to set the reinstatement period at 5 years.
So just real quick, so we'll do bodily injury first, but then I want to talk about the 5-year period of time. It's, so obviously if someone, it's death, everyone gets that, but bodily injury.
Yeah, there is some just inconsistency in the bill that some of the provisions refer to life-threatening injury versus other provisions which refer to bodily injury. I think there may be some room to harmonize those, and if you're going to use one term or the other, make sure it's consistent through the bill.
Just do life-threatening injury, and we could just, because it's already in the statute, right? So it's throughout the statute,
Yeah.
The code. So, no, I think we can make these inline adjustments on this one, if you can do that.
Yeah, we could do that easily.
So
I think it's the 5 years that maybe needs
Yeah,
more discussion.
that's the discussion. So we can make them, okay, so the motion, everyone's okay with that amendment? Okay.
Change bodily injury.
To life-threatening, yeah. So we're changing. Okay. So then the second question is the 5 years. So in their testimony, they talk about your chance for relapse. Is that,
Actually, for some reason, I don't think that made it into their letter, but the other night in discussions, they also mentioned, in addition to the other states that they cite in the letter, they mentioned that they have research which suggests that when someone has a problem with drinking and driving, the relapse rate between 2 years and 5 years, it's significantly lower after 5 years than 2 years. So I could ask them if they could share the specific studies, but I don't think that actually made it into the letter.
oh, you're right. So look, I just see the 5 years, that's their testimony, you're right. 5 years seems like a really long time to me, but, so I maybe hold it and get some more information if you guys are more comfortable with that, but 5 years seems like a really long time.
I'm just struggling with the data because,
Can you turn on?
30% relapse in 2 years, up to 80 in 5, then at least we have some rationale for on the floor about why we're being safe for, right? Okay, thank you.
So we'll just wait till we're in receipt of that information, and then 5 years still seems like a really long time to me, but, okay. All right, so we'll hold it. I think that's it. Is that it?
Thank you. Get data.
Oh, hold on, yeah, wait for, we're just gonna do Bill floor leaders real quick first before we get out. We'll gavel out, but then we'll do floor leaders. So see you all next week. All right.